Good afternoon to everybody who's joined us. Thank you very much for giving up what undoubtedly will be some of your lunch hour to come and join us with the thrilling title of Contracts and COVID with the Bristol Law Society. Bristol Law Society is celebrating its 250th year. I suppose this is the latest change to how we're supporting the local community with this series of webinars. So do keep an eye out for others that are coming your way. Spread them out to colleagues and let's see if we can make this a regular fixture in your diaries for all of your updates and training needs. I'm Stuart Henry from MW Solicitors. I specialise in contract litigation. And joining me today, I've got two fantastic speakers from Queen Square Chambers, Mike Blitz and Adam Griffiths. We've got quite a few of you joining us today. We've got over 49 logged in with over 86 registered, so I'm sure there'll be more that join in as we go. Just a quick bit of housekeeping before we move on is to advise that this webinar is being recorded and that the Q&A function is live. So if anything does pop into your mind as we're watching this, please do put questions to our panel and those will be kept anonymous. So there is no such thing as a stupid question unless it remains unasked. So without any further ado, I shall pass on to our speakers and let them take you through all of the current changes and thoughts on force majeure, frustration and contracts in a COVID world.
Absolutely, thank you very much, and very thank you very much to the Bristol Law Society for having us along. By way of brief introduction, my name is Mike Blitz. I practice in the Commercial and Employment Departments here at Queen Square Chambers. I was very grateful last year to have received my first ranking in Legal 500 at the first time of asking. And with another hat on, I've taught on the contract law course at the University of Bristol for the last 4 years. So contract is, I would say, a hidden joy of mine, but perhaps slightly less hidden, given that I do tend to talk about it to most people who can bear to listen to me. Joining me today is Adam Griffiths. Adam, before coming to the bar, was a managing director and legal counsel in Hong Kong. And in recent news for him, he's presently awaiting judgment on a long-running High Court contract case, which should hopefully be out in the next few weeks. So in terms of contracts, COVID-19, frustration and force majeure, perhaps first to just say why we thought it was worth saying a few words on this topic. Back in February or March, if we can think back that far and remember what the world was like even pre-COVID, there was very much a sense of we're all in this together, we're going to need to get through this together, and in a commercial sphere certainly feelings of goodwill and an understanding that perhaps we need not be too difficult with each other given what's going on. Certainly what we've seen in terms of the work that's coming into Chambers for us is that goodwill seems to be wearing a little thinner as perhaps people realise that this is not going to be the 2 or 3 weeks or 2 or 3 months that we perhaps thought it was in the first place. And with that comes people taking a far keener interest in their bottom lines, people taking a far keener interest in what's going to be happening next year, and whether that contract that they entered, which would make perfect sense in normal times, is actually going to be incredibly problematic. And so that's the reason that we thought it was worth touching on this, because it seems to be something that's coming through to Chambers, so it's hopefully something that is going to be landing on your desks relatively soon. And hopefully we'll be able to give you a brief overview of where the law roughly stands and where the pitfalls might be. So in terms of a summary of what we're going to be doing today, we've come up with what we think are likely to be the main issues for the clients that are going to be seeking our help. And we're then going to think about contracts that have a force majeure clause and those without. And we're then going to be going on to consider the doctrine of frustration. I'm terribly sorry, I'm told I can't be seen. If I rotate that way, can you see me on Adam's screen there? Someone could just say something in the chat function.
Yes, yeah, we can see you now, Mike.
Marvellous, that is good. Well, I'm currently looking at one screen and talking to another screen, so apologies if I'm looking backwards and forwards. So that's the summary of, I think, where we're going to be looking today. And these are the problems that we think clients are likely to be coming to us with thinking about these contracts that they've got coming up. Number one, I think, is likely to be, is this contract going to be cost effective, or is it going to be profitable given the wider circumstances and the wider restrictions? And linked to that are probably all of the other bits. So, for example, the unavailability of staff, whether that be because of furlough, self-isolation, working from home, or perhaps because employees have been made redundant. Also, whether suppliers are going to be able to fulfill their side of the bargain for whatever reason, probably not particularly a concern of your clients. Whether or not it's going to be safe to put on an event, for example, or to perform the contract as originally anticipated. Or perhaps more in a lawyer's sense, whether it's going to be illegal, in fact, to perform the contract, or at the very least against the government guidance. And we've got a word of caution on that in due course. Other things that may well crop up, the cancellation of public events, forced closure, which I think probably links back to illegality. And then the last one, perhaps more pertinent for individual private clients, perhaps weddings or other big functions and events. It's just not going to be the sort of thing that we planned to happen. And obviously our role as lawyers is to try and solve those problems, or at the very least give frank advice that the law isn't necessarily going to be able to assist. So I'll pass over to Adam now, because Adam's going to touch on a little bit more of the commercial pragmatism of these sorts of issues before we delve into the nitty-gritty of it all.
Good, yes. If I start with what is the first and best approach on the next slide. Obviously, being a barrister, it's always in my interest to recommend that people go straight to litigation, but that's clearly not what's best for clients in these circumstances. We're all faced with what is a brave new world in one sense, and it doesn't just affect us in our personal lives, but it's quite right that it affects our commercial and consumer lives as well. Renegotiation in an informal sense is invariably going to be the best approach. It's a new way to look at the contracts that you have in a pre-existing context, and also when you're looking at situations which have been very long running in an ordinary sense, in a pre-COVID world, how they can be modified now to benefit everyone. And because you may well find, from the same way that the other party can't perform strictly their obligations, you might not be able to perform yours. And so there's a quid pro quo to be had. Now, it's important to remember when renegotiating that although it's the informal approach, it may well have formal implications. And by that, I mean formality contract. So it's an amendment, and you need to be amending it in a way which the contract prescribes. So if there is an anti-oral variation clause, then make sure that you catered for that in any renegotiation. Equally, are you actually forming a new contract? Has the old contract determined and the new one begun? If so, make sure you start a new contract. It's probably a good idea to record it in writing. It's all common sense points, but it's important that when you're advising your clients, or in fact, even if within your own practices you find that you're entering new contracts with suppliers, or even the bar, then you make sure that where there is any modification, that modification is done in a pragmatic commercial sense. There are always going to be, in these sorts of situations, pressing time constraints and intervening commercial obligations. There obviously needs to be a balancing act here, and so much of this presentation will hark back to that balancing act, but always think about that contractual formality context. Of course, it's a changing situation, and so you ought to have an eye to what's going on in the future. If further restrictions come into place, if they're modified, what does that mean? And what you'll see as I move on in my presentation, look at force majeure clauses, is that the courts are becoming much more au fait, and have been for some time, with the sorts of clauses that deal with contingencies. If this happens, this is the result. If that happens, that's the result. So bear all of that in mind and recognise that contracts are very flexible objects. So, of course, negotiation being the first port of call, they might not work. And so what happens if they don't? Well, the first thing is always to consider whether or not litigation is a sensible avenue to pursue. Of course, starting litigation doesn't mean ending the litigation. You may well be able to mediate your way out of it. It may simply be a negotiating tactic. But of course, there are always cost implications when litigation is alighted upon. And if negotiations fail, you really have one of two choices. It's either cut your losses and run, or proceed onto something more formal. And in order to assess that, you'll all be very familiar with the regular need to assess your own clients and perhaps your own available financial resources and the appetite for litigation. It's obviously not for everyone. It is for me and Mike, but we're somewhat in the business of it. So do consider that. It is important. And there will be fresh considerations around coronavirus and what are people's operating capital like? Is this something which they're going to be able to service from a financial perspective for the next year or two? Some contract cases, of course, in the High Court make a year or two look like a very short duration. You may find yourself 5 years down the line still arguing about the margins of a case. So really assess what the realistic time frame of the litigation is, the cost of it, and have very frank discussions with your clients as to whether or not they fancy it. This is all the more important now because of the uncertainty of the coronavirus and the contracts which were formed pre-COVID. There is a great lack of judicial comment and precedent on pandemics and how they affect specific clauses that attempt to deal with them. There are other jurisdictions which help. Australia's got a wealth of good case law, and Hong Kong has a wealth of good case law, both of which are sensible common law jurisdictions which the courts of England and Wales are more than happy to rely upon in a more than guiding way. Of course, they're not binding on the courts here, but they are often very, very useful when seeking advice. I used to work in Hong Kong dealing on the more pre-litigation end of contractual advisory work for many years. And there is a great body and corpus and talent, really, when it comes to contractual negotiation, and the quality of law coming out of those courts is very good and often relied upon. So what then does that mean when looking at litigating? Well, there are two principal avenues, and they're in bold on this slide. It's force majeure and frustration, and that forms the bulk of what you're going to hear about today. Force majeure, which is where we'll first delve, deals with contractual construction and whether or not a clause specifically deals with the types of circumstances the parties find themselves in, whereas frustration acts more as a backstop. It simply sits there in the English law as a reliable doctrine of last resort. But again, its application is more limited and more prescriptive. And then, of course, if any of you were here for the introductory section, as people were joining us and we were chatting away, you'll have heard me make some comments about the CMA, who now consider themselves, in essence, to be a contract regulator in what is quite a novel role for them. So, moving on, if we look specifically at that available resources and appetite section, of course, some cases will clearly call for litigation in the circumstances. It will be a cut and dry, obvious point that there's been a breach. It doesn't look to be any sort of defensible position. There wasn't a clause dealing with it, and effectively frustration would have been unavailable to the innocent party. So those are the sort of easy, clear-cut cases when on just some relatively simple advice, litigation will be a sensible approach. And you go all the way to the other end of the spectrum where, of course, we're in a time of great business uncertainty. A lot of businesses don't have any financial resources, or if they do, they're reliant on service debt. And in those circumstances, is it sensible to pursue them as a target in litigation? Probably not. So do have a look at that. I've had a couple of cases in the past months. And of course, I mentioned no names, but when I've come to write my advices, I think to myself, well, I will have a quick check in company's house, only to find that the company is no longer trading. And it's always an awkward phone call to the solicitor to say, well, I've put my pen down after spending 5 or 6 hours on this advice because I've just carried out a check myself to look at something unrelated, perhaps corporate identity, proper parties, or directorship of the firm, only to find that they've ceased trading and it's probably a highly unrealistic recovery prospect. Don't overlook it, particularly now. Of course, at all times it should be in your minds, and I'm sure it normally is. But businesses are going under left, right, and centre. So make sure where it is a target, it's a sensible one. The buck doesn't always stop with companies. Of course, the doctrine of piercing the corporate veil exists, although not if you believe Lord Sumption, as he then was. Now it's all some form of very complex fiduciary arrangement. But there are alternative avenues. So don't think just because the companies cease trading, insolvent, or otherwise has low financial resources, that's the end of the story. There are other avenues to consider, obviously circumstance dependent. Right, force majeure itself. Most of you will be familiar with this term, I imagine. It's a term which comes out of the civil law. It's thought to have origins in French civil law, French civil code, and it has no domestic codified meaning, which it otherwise would in many European countries. In fact, some European countries go so far as defining what force majeure events are in their own regulations. And so it can be easy for a party to say, this is specifically an act of force majeure, and therefore I invoke the doctrine. We don't have that. What we have is contractual construction, which is, and I put an asterisk next to it, wholly case law based. There's loads of great case law here on what is and what isn't a force majeure event, but it tends to be specific to how the clause is drafted. And so there will always be a requirement to look at that drafting if you're in the state of giving advice or considering litigation, or of course, when you're actually drafting contracts in this post-COVID world, to think very carefully about whether or not you're putting something in or out of the force majeure clause, and think about all of the different permutations or developments which might occur. I'll go on to it in just a moment. It's not quite as bad as it sounds when it comes to drafting these clauses. The courts aren't quite so prescriptive as you might think, and I'll touch upon that in a moment. But that asterisk is there because there is now, and I've touched on it already, but the CMA, who normally deal with competition in markets, of course, now started to consider themselves as a regulator and prescriber in relation to what is reasonableness, specifically in consumer contracts. And they've also, within the coronavirus pandemic, alighted on certain specific contracts, for instance, accommodation, childcare, wedding and large planned events, because they recognise that these are the real areas where there may well be cause for complaint and abuse within the markets which operate in those areas. So they've taken on what is quite a new role in prescribing these, what they would say to be unfair terms. But where that sits within the legislative framework is a different and complex issue, but it's certainly led a number of companies to take relatively quick and positive action to compensate consumers in circumstances where they might otherwise not have done. So the CMA to that extent is to be commended. You'll also see within the Consumer Rights Act, Part 1, Schedule 2, unfair clauses, and again within section 57(4), both A and B of the Consumer Rights Act, when looking at services, clauses which seek to, well, of course, a force majeure clause does exactly that. It tries to establish circumstances in which one party is not liable to do something either as planned, at all, or at that right time. And so all of those clauses, when drafted, need to be held up to the bright light of the Consumer Rights Act. And again, when you come to litigation, it's very important to seek probably specific advice on whether or not the clauses which people are litigating over have within them knockout blows in the pre-existing legislation. I don't think for a moment that there was much thought given to force majeure clauses when dealing with the drafting of the Consumer Rights Act. But it's certainly being invoked now left, right and centre, and I've written a number of advices on specifically those points recently, and the litigation will quite frankly turn on it where consumers are involved. Finally, cross-border contracts, especially where civil law jurisdictions are involved. I'm not sure how many of you deal with civil law contracts and contracts drafted by civil lawyers, but they're much hotter on this than we are. But they also view it through the lens of specific jurisdictional guidance. And effectively what you'll need to look at there is governing law clauses to ensure that if England and Wales isn't in, then you're seeking specific advice in foreign territories about what is and is not a force majeure act. And finally, where England and Wales is the governing law, make sure that no matter what the foreign lawyers are coming up with, it still sits properly within the England and Wales jurisdictional framework for force majeure, which is mostly case law based, save for the Consumer Rights Act and the Unfair Contract Terms Act, where you're not dealing with consumers. That's a quick whistle stop. Obviously, moving on to the next slide. What then does a force majeure clause look like? Many of you will have seen them. The good ones fall into this camp, where they act in two ways. One defines the event, so it does the thing that the civil law might have ordinarily done. And the second one describes the contractual consequences where that event occurs. So how then does it modify things? And I've written there just how majeure, because of course it is a foreign law concept, we haven't codified it, and it's been left to the courts to determine what is and isn't. Next slide deals with that. In essence, in broad terms, it's for the parties to decide what is force majeure. They can define it however they want to, but the English law does recognise within the civil law origins at least a couple of points. One is that it has to be majeure or major. It has to be a big thing. It can't be something minor which doesn't really affect performance of the contract. In those circumstances, it's not really a force majeure clause. It's a clause of the contract governing the way in which it operates. With that said, courts are increasingly asked to interpret clauses just like that, where things stray outside of what might otherwise be a major or majeure event. There was a question asked in advance of this presentation about whether or not specific definitions need to be included. For instance, the World Health Organization declaring something to be a global pandemic. Or you might sensibly extend that to being when the government, for instance, imposes a lockdown or a serious restriction on all of the movement of peoples in the United Kingdom, or whatever it may be. Take some solace in this. The courts have been particularly keen to ensure that they're not overly prescriptive or too narrow when interpreting clauses which are in a force majeure clause. They recognise that a force majeure clause is intended to deal with instances specifically like this, and just how and when they are defined, although it's left up to the parties, the courts invoke what is being called the canon of contract of justum generis, which effectively looks at what is the general nature or tenor of the clauses which have been included to define the events, where there is afterwards. And the leading example of this, it's actually a shipping law case, and it's the case of Ambetiolis against Anton Jürgens Majeure. It's a charter party which contained the following exclusion clause. Should the vessel be detained by causes over which the charterers have no control, viz. Quarantine, ice, hurricanes, blockade, clearing the steamer after the last cargo is taken over, etc., no demurrage is to be charged, and lay days not to count. In effect, that was a charterer trying to limit the expenses they would be required to pay in one of those circumstances, but they put the words etc. at the end. And the court was asked to determine whether or not, in the case of a strike, the ETC covered that sort of delay. And Viscount Cave, as he was, then decided that that was so, because again, invoking the justum generis rule, or canon of contract, because it included those similar clauses and the words etc., they obviously intended anything to be outside of the control of the charterer, which had the effect of delaying the charter boat leaving its moorings to have been covered. And one can sensibly assume, although I must stress this hasn't been specifically tested in the circumstances of a global pandemic, although if any of the cases on my desk at the moment go the distance, it certainly will be, it can be drawn from that, that there is some safety in drafting in such a way that you include a specific provision which will catch you under justum generis with etc. or and such other events, etc., etc. So long as it's sufficiently clear and you've thought to yourself, would that cover this? Probably. You're likely to be safe. Of course, with all things, there's a great deal of litigation risk, and this is a brave new part of contract law which is rapidly being interpreted not just by the CMA but lawyers and also the legislative. So it's not cut and dry, but that's certainly a good guidebook to run by at the moment, and I can't think of a better way of doing it for now. So moving on to the second force majeure events point. I've already touched upon one ordinary contractual interpretation rule, but the other ones will as well. So, for instance, contra preferendum. If the party who's drafted the force majeure clause is attempting to rely on it, and there's ambiguity within the wording, significant ambiguity, I'd have thought, in light of jus in generis, then you're going to be in a position where it's going to be ruled in favour of the party who didn't draft it. No surprises there. I'm not going to go through every single canon of contract for you to have a little example. I'm sure you've all got them at the forefront of your mind. There's nothing magic here. This is ordinary contract law. It's just in specific circumstances. So always remember your contractual interpretation rules, and any advice you get should follow those relatively narrowly where it applies. There is, of course, common law and statute interpreting these things. They follow the civil law. A lot of guidance has been taken from domestic European jurisdictions, particularly where it comes to the common force majeure point, which is a force majeure act cannot be something which has been instigated or caused by the party relying on it. One could think perhaps logically of the man who ate the bat or the pangolin, or however this current pandemic came about. If he attempted to invoke the force majeure clause in any of his contracts, it might wrongly be said that he caused it in the first place, and therefore he's not disentitled to the benefits of the force majeure clause. The English courts are more than happy to uphold that. There's a good line of Australian jurisprudence which deals with it as well. Bear that in mind if the particular act which someone is relying upon when invoking a force majeure clause is their own doing. For instance, if they've sacked all of their staff because they're not making much money during the coronavirus period, well, that's not actually an act of force majeure. That's something they've done by their own hand. You need to look realistically at the cause. In essence, there's a need to think commercially about this. Is it actually coronavirus and a force majeure or a force majeure act which is causing the contract to be prevented from operation? Or is someone relying on that as an excuse to get out of performing what would otherwise be a very onerous contract if they've got to go and rehire staff or find new expensive suppliers? In the latter case, force majeure is not going to work. What may work is if there is a specific clause dealing with onerous contractual provisions, which the English courts are more than happy, and Welsh courts I imagine, are more than happy to start interpreting and have been for the last decade or so. But a regular force majeure clause will not cater for this, and the courts will ignore that as a defined act force majeure. Moving on to consequences then. Again, it's a matter of contract. It's however the clause is defined. But what you'll often find, particularly in contracts which are informed by civil law origins, is that the clause doesn't cause the contract to come to an absolute end. It doesn't terminate the contract. As you'll find with frustration, of course, it's a good position of the two. Force majeure allows a great deal more flexibility. It can define, for instance, a delay in performance. It can define modifications in performance. It can even define a period during which the parties renegotiate the terms and specify how that operates. The world is somewhat your oyster when drafting these, but obviously in those contracts which are already drafted, you may well find they're quite scant, because when people draft these, they tend to be from boilerplate or precedent, and they won't have been thinking about a global pandemic at the time. Obviously, you will be now in any of the contracts which you draft in the near future for occasions and supplier contracts during this period. But often, as I write there, mere suspension or modification is all that it calls for. Not always exclusively the case. A force majeure clause can just as well as frustration terminate the entire contract if that's what the parties wish, and there's nothing inherently wrong with that. But where it doesn't do that, where there is instead a modification or a suspension, there are often consequential obligations. That is, in essence, reporting, notification, and mitigation. So it's the obligation on the party who's invoked the force majeure clause often to keep the other party informed as to how long the delay is going to be, and also of the party who's not benefiting from the contract to mitigate their loss. And if that means going to someone else, then perhaps so be it. Look again to the contract. It's going to be very case specific, and probably in cases of sufficient value, a point that advice would want to be sought on in order to take the most prudent course of action, and the one which isn't going to prevent the courts from paying out if litigation ends up being necessary. And so that's it for Force Majeure as a whistle-stop tour. I'll hand over now to Mike, who will talk to you about the backstop provisions, if you like, a much more a traditional English law avenue of frustration, and again, something which is often murmured and talked about, but so very hard to get around and to invoke. And so Mike, I hope, will have with him the handbook and guide as to how to do just that. So Mike, over to you.
Marvellous, thank you. I'm just going to try and pin my video, so hopefully you'll be able to see me through the laptop. Frustration is probably one of those things that you learned about for a couple of weeks as a young, fresh-faced undergraduate, or as a young, fresh-faced postgraduate if you did the GDL or CPE or the like. That you've probably not had a huge amount of cause to think about since. And that's not because it's ignored in a bad way, but because, as I say on the slide, it's a seldom successful doctrine. And in fact, when I'm teaching my students, I really do have to hammer home to them just how difficult it can be to get home on the doctrine of frustration. He says, in normal times. And of course, we're not now in normal times. And I think we're actually now in the first period since the big flurry of litigation during World War II, where we are going to start seeing some cases where the doctrine is going to be successful. As has often been said, we have been, and depending on what sort of view you take of the future, may well again be subject to some of the biggest peacetime restrictions, peacetime legal restrictions, in living memory. And so ripe is the time, I think, for the doctrine of frustration to perhaps have its day, and for all of my eager undergraduate students to put their knowledge to good use. There are three elements we're looking at in order to establish the doctrine of frustration. And I think when we work through the three of those, we'll be able to see why in normal times it is such a narrow doctrine. Firstly, the risk of this event, the frustrating event, whatever it's going to be, can't have been allocated by the contract itself. And so in that way, the doctrine really does operate as a backstop and does respect the primacy of the parties' agreed terms between themselves. So what that means is that if you do have a valid force majeure clause, you're not really going to be wanting to think about the doctrine of frustration at all. Unless, of course, you want to think about pleading it in the alternative and the like, in which case you want to think about remedies and certainly something to get some advice on or about. The second situation is about the lack of fault, which in many ways reflects exactly what Adam was just saying. And I'll touch on that in due course, that the supervening situation can't have been the fault of either party, interestingly, not simply the party who's liable. It can't be the fault of either party. So we are really talking contracts. And it does have to be a supervening event. So an event that comes into being, however you want to think about that or define that, after the contract has been agreed. Same as force majeure. You can't say, well, this is happening, let's sign a contract now and we'll fall back on the doctrine of frustration later. It's not going to work. Instead, think about the doctrine of mistake. The third element for a successful plea of frustration is the performance must be radically different. That's one of those phrases that is somewhat nebulous in meaning, but around which the court has drawn a very, very tight line, as we'll see in a minute. And that's because the courts are very open. So this is a very drastic doctrine. This is a doctrine that completely tears apart freely negotiated contracts, with which the court should be very slow to interfere. And so perhaps don't be overly tempted by the broad wording radically different. I think probably a far better way of thinking about it is impossible, frankly. So dealing with that first element then about allocation of risk by the contract. Of course, if we do have an effective force majeure clause, then the risk is allocated and the doctrine isn't going to apply. And the court does try to steer litigation down this avenue as much as possible for obvious policy reasons. Now, it may be that we're not simply thinking about a force majeure clause, but there's other elements of the contract which allocate risk. So it need not be as explicit as a if X then Y, but you want to think about the whole contractual framework. Who seems to bear the risk for this? Who bears the risk for that? Of course, underlying that, you need to hold it up to the bright light of the Consumer Rights Act for consumers, or if you're in a business-to-business contract, the Unfair Contract Terms Act of 1977. The big thing to think about in terms of risk allocation is implied risk allocation, which is where the courts have really taken the opportunity to drag disputes out of this doctrine of frustration. And particularly there, I say on the slide, the court's going to be thinking about foreseeability of events. And the court says, well, if you made the contract at a time when the events that you're now relying on were entirely foreseeable, the fact that you didn't bother to mention them in the contract or make any contractual allocation suggests that you're simply intending that that is going to lie where it falls. Each party is going to take their own risk. And where the courts have been particularly pressing on this is failures by subcontractors or suppliers. The courts have fairly frequently said, well, it's implied into a contract, most likely by silence, that the customer doesn't care how this contract is actually performed. If you have difficulties getting supplies, that's your own lookout. If your subcontractors don't turn up to work, that's your own lookout. And so putting that back into this context and timeline of 2020, perhaps a rule of thumb might be around January, February sort of time, when we started to see the coronavirus pandemic emerging on a global scale, and its incursion into Great Britain became more a case of when than if. In those circumstances, the courts are more likely to say, well, this was happening. The fact that you didn't put it in your contract suggests that actually you've implicitly allocated the risk of what's happening. Tough luck, no frustration for you. I'll look briefly at the lack of fault, because I think Adam's touched on it very well, and it covers very similar ground. We can't be in a situation where it's a supervening event's come about by one or either party's own making. We're looking very external here. And that applies even if the decision has been made under really quite pressing circumstances. There's a case, for example, called Superservant 2, where the company had a raft of contracts which allowed them to perform salvage operations using one of either the Superservant 1 or the Superservant 2. Unfortunately for them, the Superservant 2 sank to the bottom of the ocean and couldn't be used for salvage operations. And so this company was sat with a whole raft of contracts, knowing they were going to have to cancel some of these contracts. And it all came through to litigation, and the court said, well, you had to cancel contract A. That was still on some level your choice. No frustration, doctrine does not apply. And so be wary of that. If you have clients who come to you and say, well, I have to do this, the answer is almost certainly going to be, well, yes, you probably did. But the doctrine of frustration is still going to be precluded, unfortunately. And so what might make the performance radically different? Well, your main categories that have emerged through the case law are illegality, which is going to be a big one, certainly with the government guidance, impossibility in the very strictest sense of that word, or cancellation of events, or where you have some sort of underlying joint purpose to a contract. You're going to need to be very careful with that, as you'll see in due course. What won't amount to frustration are those things I set out at the bottom. Delay, increased expense, onerousness. Again and again, the courts have said, well, if that's, when it all boils down, what it's about, then you're not going to have the doctrine of frustration. So in normal times, you can see a very restricted doctrine, but we are veering into illegality, impossibility, and cancellation. What happens then if the doctrine does apply and we can get over those hurdles? Well, first of all, the contract comes to an end. Maybe that's entirely what the client wants to do, and in the new economic landscape, that's going to be preferable for them. But do be wary in case there are clauses in there that you do want to rely on in the future. If you renegotiate, you can be thinking about those, but the whole contract will come to an end. So you may find yourself the wrong side of the lack of, for example, an arbitration clause or similar. If the statutory framework has not been disapplied, and chances are it probably won't have been disapplied if you're thinking about frustration, there's a system which I set out in the 3 bullet points there. In effect, the obligation of performance comes to an end at that point, at the time of the frustrating event. So any future payments or any future services are not due. The contract is then, to some extent, unwound. And I say to some extent because the statutory framework is not based on any particular logic at all. I've sat there for hours and hours and tried to work out what on earth is this trying to do, and the answer is I have absolutely no idea at all. It's going to depend entirely on the structure of the contract when various services and payments are due. In general, anything that is payment and has been paid is refunded, subject to the court's ability to set off various expenses, and there's a limit on that of a just sum. And where past services have been provided, the court is enabled to provide compensation for a valuable benefit. A valuable benefit is something that's been subject to much litigation, and even some 70 years after the relevant act, we're still really no further down the line on trying to define what it is. So again, if you think you're in that territory, definitely something to seek advice on, we think. I'm going to hand back over to Adam now to touch on CMA regulation, and then we're going to run through those 8 statements that we touched on at the beginning and see if we can work out whether force majeure or frustration is going to help any client that turns up asking about that.
Excellent. Well, you've heard me say it a couple of times now, so I better get into some detail into what the CMA are doing. Although, again, anyone who was here at the outset will know that I think this is probably a topic worthy of an entire presentation on its own. But that might be folly because things are changing so quickly at the CMA. They've already lost their senior executive to this debacle who believed that he was not given sufficient state powers through the legislative. He walked, fearing that the CMA would come under criticism for not doing enough for consumer contracts and also general market regulation. You'll have seen in the press at the outset all of the cries of the public from people raising the prices of hand sanitizer. There was, I think, a great deal of backlash from the public and, by extension, Parliament at that time. And that's when I perceive, at least, the CMA really stepped up to the plate and thought, well, this is an entire industry which is attempting to profit from a situation which is a market abuse, and therefore we should step in. And the way in which they did that was setting up a COVID-19 task force. What, you may quite sensibly ask, was the COVID-19 task force's a specific remit? Well, they decided it was to look at contracts falling into broadly 3 categories. Those that dealt with large-scale events like weddings, holiday lets and rentals, and also childcare, recognising that that was important for the public and something which may well be abused at this time. Now, they have published a number of different documents, some contemporaneous and some pre-existing. In terms of pre-existing documentation the CMA have produced of benefit is the CMA's Unfair Contract Terms Guidance, that's CMA Guidance Note 37. The particular parts of that which are of use are at paragraphs 513.1, 516.1, 517.1. For anyone who's looking for some light bedtime reading, they deal in essence with the CMA's attempts to define what is an unfair contract term. And that is of use when looking at force majeure clauses because they are potentially unfair. They seek to limit one party's liability in specific circumstances. That is an area which the CMA have themselves relied upon in their second useful publication on this point, which can be found on the 30th of April 2020 on their website, and it's the Coronavirus, brackets COVID-19, and brackets Pandemic, Consumer Contracts, Cancellation and Refunds note. I'm not going to recite the whole of that document, but in essence, it reached the same conclusions, perhaps unsurprisingly, as their previous Guidance Note 37. Effectively, if one party is liable to refund a sum paid for another one, if there are any deductions necessary for that sum, then it needs to be for a valuable service already performed. It is in many respects reminiscent of exactly how frustration operates, and I've got no specific knowledge of who wrote this guidance note or who put their minds to it, but it strikes me that it was someone who was looking at frustration at the same time, and they thought, well, how does frustration operate? We should seek to mimic the operation of a force majeure clause in just such circumstances. And so that's specifically what that guidance note does. It's had a great deal of positive impact in the consumer markets generally. There are anecdotally at least swathes of people who have had the whole price of their holidays refunded by organisations who would otherwise have retained those funds, simply on the basis that the CMA said we're going to press against anyone who doesn't do this and bring enforcement action. They do have some teeth, the CMA. They can issue enhanced consumer measures notices, and they can in fact bring proceedings against parties who breach those, or breach in a more general sense the market abuse provisions. That is a strong weapon in the arsenal against companies who are seeking to A, capitalise on these events, and B, seeking to do consumers out of sums wholesale in order to prop their businesses up. So don't overlook the CMA, certainly if you're acting for consumers, and if you're acting for providers of services, then keep a watchful eye on them and what they say, because it may well turn out that the contracts that you're advising on are regulated by the CMA in a manner which you would have otherwise unexpected or unanticipated. So that's the CMA. It is a very developing set of circumstances, and they keep doing relatively novel and useful things. So keeping an eye on that website is probably a good thing to do. So moving on, we now start to deal with those 8 points which Mike mentioned. So we can probably be on the same screen if we can get away with that. This shouldn't take very long, particularly where it comes down to force majeure, because as you will become rapidly bored of hearing me say, if I was to answer to all of these questions, it depends so heavily on how the term of the clause was drafted. So always look to that clause when trying to interpret these sorts of situations. But without further ado, we better start with the first one. So, Mike.
Is it cost effective? Is it profitable? Doctrine of frustration is not going to be your friend here. Don't even think about trying it. You will have an angry judge who will not be happy and will probably sting the costs.
Yeah, and when it comes to force majeure, it's a similar-ish story, although there's some good Australian jurisprudence here in that case, which I've put up on the slide. In essence, where the clause governs that particular set of circumstances, the courts are increasingly likely to say, it might not be force majeure in a typical sense, but freedom of contract, the parties have decided to allocate risk in these set circumstances. It's not a traditionalist view of the force majeure clause, but a very well drafted force majeure clause, particularly one, for instance, which is split into several parts, dealing, if it's being drafted today, with the COVID-19 pandemic. That would be a very sensible way of dealing with things. It's not a supervening act, but again, if it's not profitable, there may well be a mechanism contractually drafted to deal specifically with that onerous provision.
Number 2, my staff are unavailable. This is one where the doctrine of frustration might be a little bit more of assistance to you, though you've got quite a narrow window to aim at. The authorities say that when you have staff who are physically unavailable for an extended period, usually as a result of death, serious personal injury, and the like, and where you have a contract for personal service, that is not just a contract for a service to be performed, but for it to be performed by a specific person, then that can be a frustrating event. Again, something to certainly I'd say to seek advice on. Touching on self-isolation, you've got quite a few issues here. Firstly, track and trace isolation seems to be a moral obligation only, as opposed to travel self-isolation, which is legal. Where you've got people who are made furlough or made redundant, that's probably not going to count as physical unavailability, but you may have a window here depending on the circumstances.
And as for force majeure, this is classic justum generis territory. It's highly unlikely that your force majeure clause is going to include where my staff aren't available, I'm released from providing all contractual obligations. No one thinks like that, and it'd be very unlikely for a party to sign up to that sort of contract in the first place. But where you have the definitions section of the force majeure clause with a catch-all term at the end and justum generis applies, well, we're all the way back into that case of Ambateos and Anton Jürgen's Majeure works. And there's another good case, it's called Caltex Oil, which deals specifically with strike action being caught for these purposes. But again, it needs to be mixed with a force majeure event. It can't be an act specifically and only of the relying party's hand. You can't sack all of your staff and then try and claim it as a force majeure event. That's nonsense.
My suppliers can't provide as promised. Unfortunately, back to what seems to be my chorus at the moment, the consumer isn't going to be concerned with how the contract is fulfilled, simply that it is fulfilled. So the doctrine of frustration is not going to assist here.
Seems like Mike's undergrad students are still going to be unable to use all of that good tuition which they receive from him. But force majeure, again, may work. You're hearing a similar refrain from me again. Go check the drafting of the contract. But where the other party knows that the supplier is relied upon in the circumstances of the contract, and the non-provision of that supplier is wholly blameless on the party relying on it, then you may well be into force majeure territory if it's mixed with a force majeure defined event.
Marvellous. It's not safe. One of those phrases that's going to require interrogation. As far as the doctrine of frustration is concerned, one we need to think about, well, once we've undertaken our risk assessments, done all we can, what's left? Is it still illegal? Is it still impossible? If so, then the doctrine of frustration may be able to help you. If actually, when you boil it down, it's just a matter of profitability and resources, unlikely.
And as to force majeure, we're back into contractual construction doctrines. What was in the minds of the parties? What were they attempting to do when drafting the force majeure clause? If the contract was all about safety, if there was an element of that which was always going to be pivotal to the performance of the contract, then a force majeure clause is likely to work. Whereas if it's peripheral or simply being used as an excuse, the courts are likely to see through it. But of course, look at how it's drafted.
It's illegal or against the government guidance, with the big word of caution as someone who has very boringly been following the ebbs and flows of the coronavirus legislation as it comes out. The two have never coincided. So be sure to look at the regulations, which are currently the health protection, brackets coronavirus England, close brackets, open brackets, number 2, close brackets regulations of 2020. All good fun. Illegality is where frustration is likely to be of assistance. What the cases have said is, well, how much is it restricted and for how long? The key case here is a case called Metropolitan Water Board and Dick Kerr, which concerned construction towards the beginning of the Second World War, and the court said all construction has been banned and the duration of the war is indefinite. So we do have a frustrating event of indefinite restrictions. Well, it probably depends on how optimistic or pessimistic a view you take about whether we will have vaccines and the like, but doctrine of frustration certainly want to explore if we end up in this situation.
And as to force majeure on that point, it's fairly uncertain because, of course, it hasn't been domestically treated yet, whether or not the coronavirus pandemic is inherently a force majeure. Expect that to change very soon. As I said, I'm sat on, it must be 3 or 4 issued opinions, and I think I'm at least on 3 sets of pleadings dealing specifically with this point. I can't think that it's going to stay out of the higher courts for very long. There are going to be some very expensive contracts and some very onerous contracts people are going to want to escape from, and the courts are going to be forced to start interpreting force majeure clauses in these circumstances. But for now, it's fairly likely that a properly drafted force majeure clause that considered a pandemic of some sort will catch the repercussions of force majeure where there isn't some sort of relying party hand.
The third party event has been cancelled. One very popular for us when we set our exams, because there are 2 conflicting authorities from the same year with the same judges relating to the cancelled coronation in the early 1900s. Very unpredictable. if you're thinking about the cancellation of a third-party event or some sort of contract where both parties were on some sort of joint venture, what you're looking to distinguish is, was it a joint assumption on behalf of the parties, that's why the situation would be as is, or was it just a simple opportunity for profit? Example given of the taxi driver not being concerned whether the Epsom Derby is in fact going ahead, only that there's far more likely to be paying fares coming from the local station.
This is a good one for force majeure because it almost certainly doesn't apply. If force majeure doesn't concern itself with force minor, if your small event has been cancelled, that almost certainly isn't a major act of God, war, famine, flood, fire. But where the event has been cancelled, and regardless of that, the global pandemic would have caused the event to be completely inoperable, there's a chance you can get in under sort of, it would be a bit of a fudge, but it's certainly an arguable position and a good one for negotiation point, but unlikely to be a pure form force majeure point. But of course, you could draft within your contract clause dealing specifically with that, and contemporary contracts, that should certainly be what you're looking to do, to define the event that's meant to go ahead and what happens if it doesn't go ahead for any reason, not just the coronavirus pandemic.
I've been forced to close. Well, why is the answer. If it's illegality, then we're in the remit of illegality. If it's because it's uneconomical to operate at the moment, then no.
And similar story for force majeure on this one. You need to look at the cause of the closure. If the cause of the closure was because the government had quite literally prevented you from operating, they've said you must shut, then you're probably in force majeure territory if your clause is so well drafted. Otherwise, if you've decided to close, so not really answering the question there, you've been forced to close, but if you've decided to close, that's your own decision, and no chance of force majeure.
And finally, it's not going to be the sort of thing that we planned. Well, when we're in the territory of frustration, how something is done is not irrelevant. You're looking at, when it boils down to, what can you actually do and why? Is it illegal? Is it impossible to do? Or again, the same frame, is it just a matter of profitability and resources?
And when we come to force majeure and the contract provisions, it's unlikely to be covered by a traditional force majeure clause. What you're probably looking at is an ordinary breach of contract, or simply not doing the thing that we asked you to do. If you obviously meet the high watermark of frustration, if there isn't a force majeure clause, or where there is a force majeure clause, if you meet the high watermark of that definition, then you need not concern yourself with another breach, but otherwise you're looking at contractual breach and remedies.
And there we are. That we hope has been useful in a whistle-stop tour sort of way. Obviously, Adam and I take a somewhat bizarre delight in thinking about these sorts of things. And so we're more than happy to field questions either now or informally if you want to speak with us in chambers.
Yeah, and after this event, those slides are going to be available for people to download. I believe this entire hour-long presentation is going to be put up on the internet, but all and sundry to watch. Take a note or keep up with, then please feel free to go back to that, or as ever, ask your questions now or later. It's a particularly interesting topic and one which we delight in talking about.
Great, well, thank you very much, chaps. All that remains is for me, on behalf of all the delegates, to thank both Mike and Adam for their time today in updating us for that. We do have a question which has come up, which I shall field to you now, which is, if one party cancels the contract stating it is frustrated, is the other party entitled to any potential cancellation fees? Now, I assume that's on the basis that there is a clause within the contract that entitles such cancellation fees rather than a standard position, but perhaps you could give us a brief view on that.
Yeah, absolutely. So it depends really when that cancellation fee is said to be due. If you have a frustrating event, then that brings the contract to an end from the moment of that frustrating event. And so if a cancellation fee is due later down the line, for example, when a decision is made, then that contract is no more and that term isn't going to be applying. I can't imagine a situation where the cancellation would come after the event, just as purely on the chronology of it. So I think the answer is, once you're in a frustrating event situation, all bets are off and you're unwinding the contract using that statutory framework.
Yeah, I mean, it's worth noting there that within the statutory framework of frustration, there is the entitlement for the party to effectively be recompensed for any reasonable fees incurred. And so, in essence, a cancellation fee is statutorily provided, but it always has to be reasonable. So you can't have an unreasonable contractual cancellation fee, but a reasonable one is provided for within the statutory framework in any event. Is that right, Mike?
Yeah, absolutely. It comes on under the, again, it gets difficult because the amount of that cancellation fee can't in effect exceed payments that have already been made. It gets very, very technical. The best advice really for clients is be prepared to justify what you've spent. Don't just fall back on a fee that's in the contract. How much did this actually cost you?
Great. Well, thank you very much. I can't see that we've had any other questions drop in, so I'll wrap up by saying thank you ever so much to everybody for attending, and wish you well on the rest of your afternoon. Thank you.